Welcome back. The Constitutional Court found today that Public Protector Advocate Busisiwe Mkhwebane lied under oath and submitted falsehoods to the country's highest court. Judges today ruled that she must personally pay the costs of a portion of the Reserve Bank's legal fees for their application that eventually overturned her findings in the ABSA case. In 2017, Mkhwebane found that Parliament must change the Constitution to change the mandate of the Reserve Bank after her investigation into the bailout of Bankcorp in the 1990s. Her findings were overturned in the High Court, and today judges ruled, 8 judges to 2, that she should carry some of those costs. Justin Ramages is an attorney at TGR Attorneys. He's with me now. Justin, good evening. Thank you so much for coming in.
Thank you for having me.
All right, firstly, let's just understand this clearly. When the Constitutional Court says that someone submitted falsehoods and submitted them under oath, what do they mean? Are they saying she lied?
I think the words are clear. Where the shoe pinched, you try to move into a position where you're okay. And I think the court has gone through in the second leg of the judgment, the first part obviously being with Mkhwebane, where the majority said, listen, you've submitted these provisions in the High Court, and this was your position. And as soon as you get backed into a corner, you keep on explaining it without reasonable explanation. And where that leaves you is in a position where you're either biased or incompetent. And what we've concluded is there's surely bias in this regard with respect to the lack of submissions on her part to the court. In addition to that, the second leg of it is obviously the economic part, where she said, listen, she relied on economic advice, and a report and an affidavit is based on that. But once that was tested, she was found to be wanting, which is telling for a Chapter 9 institution who's responsible for conducting very serious activities in regard to root out state malfeasance, and where you say you're supposed to do that and you're actually doing the alternative, it's disappointing.
You also, if I remember correctly, you actually have to be an advocate to be the public protector in the first place. Sure.
And what was interesting, we see that now there's a movement trying to remove her as an advocate on these grounds. So it's disappointing.
Okay, let's look at that. I mean, the constitutional clause around the public protector, it says that basically there are 3 grounds on which someone can be removed. It can be misconduct, incapacity, or incompetence.
Sure.
Would this then, the fact that she lied under oath, come under misconduct?
Surely. I think on a broad interpretation that would fall squarely in that leg. You see, what we have is a public protector who's responsible for, the name says it all, protecting the public. But when there's elements of bias involved, or when her report or affidavits are predicated on falsehoods, it becomes problematic. And surely steps need to be taken against her. If she's put in a position of power that's responsible for protecting our constitutional democracy, and she abuses that office, that becomes a problem.
Okay. Both President Cyril Ramaphosa and the Public Enterprises, Mr. PRAVIN Gordhan, they're lodging review applications of her findings against them. Okay. One is in the sort of SARS issue. The other one, of course, is about the financing of his ANC leadership campaign. The finding today presumably strengthens their cases?
Well, we're going to have to see, just because you perform poorly in one aspect of your job doesn't mean that spills over into the next aspect of your job. So we need to be fair. And that would be their position. But her position is she did a thorough job. But I don't know if you recall, there was a newspaper article several weeks ago by, I think it was Jacques Poe, talking about the credibility of her sources, in addition to the rationality of her findings. And we also have to look back, especially in the PRAVIN Gordhan's case. There's been a history of people who said, listen, you did the right thing, and now the public protector comes along and says, listen, I think it's a different situation. So one would get the sense historically that there's a lack of performance. Whether it is in this situation, we have to see. I think the judicial forum is the correct way to ventilate those ideas.
So each case has to be settled on its own merits?
Right, okay. Which is fair and just.
Okay. I brought my constitution along for this interview because I wanted to read this out myself. I was surprised when I came across this, and it talks about how a public protector would be removed. So you would go through the process, there would be a committee investigation, and then the motion would have to be adopted with a supporting vote of at least 2/3 of the members of the Assembly. It then says, the President may suspend a person from office at any time after the start of proceedings of a committee of the National Assembly for the removal of that person.
Sure.
How do you read that? Does that mean then that from the moment the chairperson of that committee says, we're now going to consider removing you, the President could suspend her?
Sure. So on a reading, that's section 194, subsection 3, if I'm correct,
Yes.
What she's pointing out, so what the provision tells us is that there is powers granted to the president to suspend her from exercising her duty, and understandably so. If there's misconduct or lack of capacity, you would want to suspend or rein in that person from conducting those activities. So surely those provisions must be aimed at regulating and protecting the state, especially if we have a pattern. Let's assume let's for argument's sake say it's a pattern of misconduct or inability on her side.
She would obviously, if he did suspend her, she would be able to challenge him in court on that too. Sure.
And she would do that. We see she's and she should, because the court would be in a position to make a finding on that. But once it goes into the realm of the National Assembly making a finding, or the Committee of the National Assembly making a finding against her, 2/3 removing her for misconduct, and there's a judgment which supports that, she's in very precarious territory.
Okay. There's another legal argument that's been playing out around all of this, which is that in the PRAVIN GORDHAN matter, in the public enterprises matter, and on Friday, the Public Protector Advocate Mkhwebane said that the President must implement her remedial action against GORDHAN, even though GORDHAN has gone to court to have that remedial action overturned. Now, what the Public Protector's Office said again this morning on the SABC was that they still stick to that. Are they right?
So there's a lot of arguments around that. I mean, like it was widely ventilated in the public domain, and there are a lot of disagreements about that. But where you have administrative action taken that has findings and recommendations, we know from the EFF decision that you have to abide. You can't just ignore it, right? But when the validity of those decisions are challenged, are you going to implement a investigative arm of state saying, listen, this is what we found, and you're challenging the validity, but now you have to apply? It doesn't make sense. The court, the arena of the court is there to make sure that, listen, due process is followed, we follow the correct procedures, and we're not implementing invalid actions. It needs to be tested.
Justin Ramages, thank you very much indeed. I'm sure there'll be plenty more legal documents to look at as this continues. Justin Ramages is an attorney at TGR Attorneys.